everybody, depending on where you are in the world right now. My name is Emilie Max. I'm a researcher at the Geneva Academy of International Humanitarian and Human Rights. And it is my great pleasure and honor to see so many of you online today and interested in today's event on the litigation of international humanitarian law before the European Court of Human Rights. Before introducing our panelists, I'll start with a few information on the Academy and also on housekeeping. So for those of you who do not know the Academy, we are a joint center of the University of Geneva and the Graduate Institute. We provide postgraduate education on areas of international law related to armed conflict and also transitional justice through an LLM program, an executive master's, and also a master's in transitional justice. And we also conduct legal and policy research on the same areas. Today's event is part of a series called the IHL Talks, which we organized about 6 or 7 times per year. Today's event is the 6th of the series in 2020, and I'm happy that the series will continue in 2021. If you have any topic that you would like to see addressed or have burning questions of, please send us an email. We're always happy to receive suggestions. That's it. And then on housekeeping, I assume that by now, 7 months or 8 months into COVID-19, you're all familiar with Zoom. But just so you know, you'll be able to hear from our panelists and myself and also see us. We've disabled your cameras and microphones, but we would be very happy to have you interact with our speakers today through the chat feature. We'll have a Q&A session, and I hope it will be lively. So please ask questions through the chat. We'll take them in a first come, first served basis, but we might also group them in clusters if there are several questions addressing the same issue. So now, without further ado, I'd like to introduce our speakers this afternoon. So we have Michael O'Boyle, who is the former registrar at the European Court of Human Rights and is now retired. We have Professor Andrew Clapham, who is a professor here at the Graduate Institute in Geneva in international law. And then we have, last but not least, Tamar Tomashvili, who is an associate professor at the Free University of Tbilisi and a former public servant with the government of Georgia. She's here in her personal capacity. Each of the speakers will have about 12 minutes for their presentation, and then we'll switch to the Q&A session. So I would very much like to first give the floor to Michael O'Boyle for this presentation.
Good afternoon, everybody, and I hope everything is okay. It's my pleasure to talk to you today briefly about the interplay between the European Convention on Human Rights and principles of international humanitarian law. This is a rather complex subject, and to be restricted to 12 minutes is quite a challenge. So what I thought I would do is just make a few general remarks about the court's approach to principles of IHL and some of the more interesting cases that have come before the court, although obviously time will prevent me from going into great detail. I think my starting point must be that the court has made it clear that its role is to determine whether or not there has been a violation of one of the rights and freedoms set out in the convention, and that it does not have jurisdiction as such to determine whether or not there has been a violation of international humanitarian law. It's a forum that is limited to the protection of human rights. And recently, this issue arose in a rather dramatic way in the conflict between Armenia and Azerbaijan that hopefully has just come to an end. Both Armenia and Azerbaijan brought cases before the court, making various allegations. And both of them asked for interim measures in September. The court granted interim measures in respect of both parties, and asking them to refrain from conduct or action that would violate the convention rights of the civilian population and to respect their engagements under the convention. Then in October, a new request for interim measures was made to the court by both of the parties. And this request referred to allegations that various provisions of IHL were being infringed by the parties concerning the treatment of prisoners of war and other issues. And there the court issued a press release saying that in what was a very clear response, that such subject matter, that's to say the violation of IHL, is not a matter that falls within the court's jurisdiction, and that the issues raised by both governments were already covered by the interim measures decision that had been taken in September. So that, to my mind, is the clearest and most recent statement that the court has made, that it has no jurisdiction as such to adjudicate on IHL issues. But of course, that is not the end of the story. What the court is saying here is that it will only adjudicate on whether convention rights have been violated. However, to make that determination, it may have to have regard to issues of IHL. This is nicely illustrated by a quotation from the judgment in Varnava against Turkey. Here the court said, Article 2, that's the right to life, must be interpreted as far as possible in the light of general principles of international law, including the rules of IHL, which play an indispensable and universally accepted role in mitigating the savagery and inhumanity of armed conflict. The court therefore finds that in a zone of international conflict, contracting states are under an obligation to protect the lives of those not or no longer engaged in hostilities. This would extend to the provision of medical assistance to the wounded, where combatants have died or succumbed to their wounds. The need for accountability would necessitate proper disposal of remains and require the authorities to collect and provide information about the identity or fate of those concerned, or permit the bodies like the ICRC to do so. So the approach of the court is to interpret convention rights against the background of principles of international law, including principles of international humanitarian law. Now, the convention itself doesn't mention humanitarian law directly, but there are provisions that require the court to look at it. Let me say something briefly about derogation. Article 15 of the convention, as you know, enables the state, when in a situation of war or public emergency, which threatens the life of the nation, to take measures in derogation from the rights in the convention. But not all the rights. There are, of course, limitations as regards the right to life and slavery and retrospectivity, the criminal law, and so forth. So the first issue that arises is this reference to war. In times of war or other public emergency, what is meant by that? And you get no help from the convention, nor do you get any help from the protocols or from the court's interpretation. Does war is it limited to international armed conflict, or may it encompass non-international armed conflict? Nor is it clear whether the war is a territorial war or an extraterritorial war. So there's a vital issue of IHL that is yet to be determined. The most important provision in the derogation provision is the question of proportionality. The state is allowed to derogate from rights, but it must take all steps that are strictly required by the exigencies of the situation, provided such measures are not inconsistent with its other obligations under international law. These other obligations may, of course, be treaty law or customary law, but also principles of international humanitarian law. This is not a provision that has been litigated It has come up from time to time, and no doubt in cases that raise issues of humanitarian law, it will come up again. And the third point relates to the right to life. As I mentioned, you can't derogate from the right to life, except, according to Article 15, paragraph 2, except in respect of deaths resulting from lawful acts of war. So there's a direct invitation of the treaty terms to the court to determine what is meant by a lawful act of war. This means that where there's an armed conflict and the state has derogated, the court may be called upon to examine the complicated international human rights rules about the use of deadly force. And as you know, these rules are less protective of the right to life as interpreted in the court's case law, because they permit directly the killing of combatants, whether or not they're posing any threat. And also because, as regards civilian deaths, the assessment of proportionality enables the state to balance the military advantage against the risk to civilian lives. Now, in the case law of the convention, sometimes the states involved in an armed conflict simply don't invoke Article 15, and that leaves the court in quite a quandary. In fact, in the pending case that I'm sure Tamar will be talking about, the case of Georgia against Russia too, neither party derogated under Article 15. And so the Russian authorities come to the court in the context of that case, and they say, there's nothing that the court can investigate, because this is essentially a case about violations or alleged violations of principles of humanitarian law. And the Georgian response is that there's been no derogation, so the court must apply its traditional interpretation of Article 2 of the Convention. And so that issue, which is a major issue in that case, is pending before the court, and it has been pending since the admissibility decision in 2011. Perhaps, and maybe I'll bring this to an end with a reference to a very important case called Hassan against the United Kingdom, which is, apart from the Varnava case, is the most specific invocation of humanitarian law that has occurred in the context of an individual case. In the case of Hassan, it takes place in Iraq. The applicant had been arrested. He was in possession of weapons. He was suspected either of being a combatant or of being a danger to national security. So he was detained. And essentially his case before the court involved an allegation that Article 5 of the Convention had been violated. But of course, Article 5 of the Convention was not drafted with the problems that occur in armed conflict in mind. And so the provisions of that article, which define instances where the deprivation of detention may be justified, simply didn't apply to a war theater. And here the court said extremely clearly that it could not ignore the context in which the detention took place, and that it must interpret Article 5, again with Varnava in mind, against the background of principles of international humanitarian law, and with reference to the Geneva Convention, provisions of the Geneva Convention numbers 3 and 4, they decided that it would be lawful to arrest a person either on the basis that he was a combatant or that he was a danger to security. But then added the very important provisos that this only applies where the state itself invokes international humanitarian law as a justification for the detention. And secondly, the whole detention process must be subject to various safeguards against arbitrary detention, which they considered the various overseas possibilities under the Geneva Conventions had taken place. And so no issue arose from that standpoint. So there you have a case where the court got its feet muddy, so to speak, by straying directly from human rights law and walking ever so briefly, but rather clearly in the area of international humanitarian law, illustrating that, to my mind, it is prepared to do so when confronted with human rights problems that occur in situations of armed conflict, whether that's the case in respect of armed conflict of a non-international character remains to be seen. I'm going to end by simply saying very briefly that the other interesting cases in this area have occurred under Article 7 of the Convention, which concerns the non-retroactivity of the criminal law and punishments. And there are two cases that I'll refer to. One is the case of Korbeli against Hungary, and the other is a case of Kononov against Latvia. I don't have any time to go into in great detail, but the problems that the court was faced with in these cases, which involved criminal determinations of whether the applicants had committed offenses in the 1940s, and whether or not that determination in modern day times would violate Article 7. And in order to reach a determination in these cases, the court had to go into a question of intertemporal law and find out whether in the 1940s, when the various offenses, in this case killings, had taken place, were the killings in violation of provisions of humanitarian law. So then again, not only was it faced with the complication of determining what the state of humanitarian law is, which is a real difficulty. This is a complex area of law. But even worse, it had to determine what the state of the development of humanitarian law was in the 1940s. I'll just end by saying that it's clear from the large number of interstate cases that are pending before the court and that concern really important issues of life and death, that this is a growth area and that the court will be bound to make extremely important pronouncements in the judgments in these cases on the subject under consideration. Thank you for your patience.
Thank you so much, Michael, for highlighting the different hooks for IHL in the convention and the court's practice, especially, I guess, with regards to Article 7, which is probably a little bit less well known than Article 5. I'm now happy to give the floor to Tamar-Jvili for your presentation and on notably interstate cases.
Thank you, Emily. Good morning, good afternoon, and good evening. I guess I will start with two issues, basically two concerns, I think, which has been recently noted by scholars, practitioners, and also reverted to the states with respect to the interstate applications which are pending before the European Court of Human Rights, which specifically relate to the armed conflict situation, which is 8 of them, starting with Georgia versus Russia, the second number of cases being Ukraine versus Russian Federation, and now recently in September, October, having a new interstate applications between Armenia and Azerbaijan. I think the two primary concerns which we hear is the first, that there is somehow the hijacking of the Human Rights Forum, that is the European Court of Human Rights, for public international law issues, pertinently the sovereignty claims, also attempts by these states to use it for determination of the legal status of the territory when we're specifically talking about the occupation, or the sovereignty claims like what we are seeing in Crimea, or also the questions related to Nagorno-Karabakh. And I will try to add that question because as it has been noted, we will be talking about the jurisdictional issues as well. But the first note on the first concern from my perspective is that because the European Convention on Human Rights envisages within the Article 33 very specifically to have an interstate claims brought before the court, as well as I perceive that this convention is an erga omnes partes convention, which allows the opportunity for states to claim and bring the cases before the court for the violation of the human rights by other states. This opportunity to actually go beyond individual complaints is within the potential of the court. However, as Michael has correctly noted, the question is how far we can use other fields of public international law, specifically humanitarian law, for the interpretation of the treaty, because we are talking about treaty-based mechanism. And I will come back to this issue when we will be addressing the jurisdiction. The second concern is that if we will be using humanitarian law issues, and Michael actually mentioned one of the critical elements is right to life and targeting, that somehow we might be lowering the standard of the protection which is guaranteed by the human rights law. And in this perspective, maybe because actually when it was called QD, and I looked from a lot of human rights issues from theoretical perspective, and then going and being a representative of government, I realized that the treaties do not exist in abstractia, but they have to be feasible, reasonable, and reachable and implementable by the states. Therefore, I think what the court has rightfully in the practice has done, and I have experienced that basically also in relation to my country, is that it has to take into consideration the context, how the human rights law are applied in a very specific context, and be realistic. It doesn't mean that it should infringe upon rights of the persons, but it has to take into consideration the reality on the ground. And that is particularly relevant when we're talking about the armed conflict and theaters of war, which has its own specificity. And we will be coming about to this issue when we somehow perhaps address the issue related to specific rights, which is usually decided by the court on the merits. Now, what I would like to do is to zoom out from being maybe a scholar or reading about the cases and think from a strategic litigator. Imagine that the armed conflict has just recently started and you have been tasked by your government to give an advice. What is the best forum within the European space, because we are talking about the European Court of Human Rights, for taking your claims? And by saying this, I do not mean necessarily only the state claims, because state is nothing else if not the protection of its own nationals, its individuals, for the benefit of your people, to stop whether it's an ethnic cleansing or a massive violation of human rights, which is ongoing. And when you have to take into consideration as a lawyer that you might be actually negotiating a ceasefire agreement, you might have already negotiated a ceasefire agreement, which is just 5-6 points, nothing else. So you have to think about the peace negotiation and peace treaty, how you will address the issues. But at the same time, you want to use the existing mechanisms on international level for the protection of the rights and also the legal claims, which might be related to territorial claims or sovereignty claims, if I can summarize them this way. And in this respect, what comes in the mind within the European space is that you need to find a court which is well-respected, authoritative, as well as the court which has a jurisdiction. And of course, the mind, if you are an international lawyer, which comes to you is you look at the International Court of Justice, the World Court, and you look at the other regional mechanisms, judicial bodies, which is European Court of Human Rights. And if you look at from the 2008 perspective, you see that you have a practice where the both forums had been employed in situations of armed conflict. Now, in relation to the ICJ, we always have a jurisdictional bar, which is based on the statute of the court, whether you can take the specific cases to the court, because both parties, the applicant and respondent, have recognized the jurisdiction of the court, which might be challenging. And I think this is a challenge which is quite often brought before Georgia and Ukraine when there are discussions about the ongoing parallel proceedings before several courts. And the second element is, as I've mentioned, is looking at the regional judicial institution, which is the European Court of Human Rights, which has served actually as a protector of human rights prior to the last, let's say, last cases of armed conflict in an already existing interstate case between Cyprus and Turkey with respect to occupied territories of northern Cyprus, as a strong guardian and interpreter of the human rights issues. Therefore, there is a practice. With respect to Georgia, there has been also the practice of the first interstate application in 2006. And it's a court which is well respected, which actually is quite fast, because quite often we forget that in ongoing armed conflict, when we are talking about the violation of the human rights, which is ongoing, you need to stop them also with all possible mechanisms. Again, I will limit my discussion about the legal mechanism, not going into the semi-political or quasi-judicial mechanisms that we can have in the United Nations. Therefore, also, again, Michael mentioned just Armenia, Azerbaijan, which is a clear example of the interim measures which work and which is respected usually by the parties. You see it as an opportunity to take the case before the court. So I think it comes with no surprise when we are talking about the strategic litigation before the European Court of Human Rights, when the armed conflict is ongoing and there are the violations of the human rights. And I will not engulf into the discussion that the human rights apply during the armed conflict. I think all of us would agree about that. It comes no surprise that the state will take this step before the court, which has established this practice. Therefore, I see it not only, I believe, perhaps coming to my first concern, as an opportunity for the states to hijack the process and bring the legal public international law issues before the European Court of Human Rights, but actually truly a mechanism that they try to employ for the protection and respect of individual rights, for the benefits of individuals, because I believe that if the applicant state does not understand that and cannot actually undergo this threshold, that the decision of the court should be in favor and for the benefits of individual, it will lose the case. It also comes when we are talking about the just satisfaction, which has to be granted by the court when we are talking about the interstate applications. Now, what are the challenges? And I see that I maybe have 2-3 minutes. I think the issue of the sovereignty of the over the territory is an issue which inevitably comes when we talk about the jurisdiction in interstate cases. And I believe this is an interesting case, not only for Georgia, but also when we are talking about Ukraine and Ukraine case before the European Court of Human Rights with respect to Crimea. If you would be interested, it's very interesting to look at the website of the court, where there is the oral proceedings, oral hearings on admissibility, and you can observe the position of the states on admissibility level, and also what we are seeing now in Armenia-Azerbaijan case. Now, where I think the court stands at this moment from how the court can actually be less challenged by the territoriality claims, which inevitably I think might be an interest of an applicant state, but even the applicant state can write its memorial so as not to be, let's say, objective and not putting a state in the court in a difficult situation. It's looking at the extraterritorial control as a de facto control of the territory, rather than trying to persuade the court to use term occupation, actually to talk about the de facto control of the territory, or control or the authority exercised by the state over the local administration. And I think this is the approach that the court has taken in several cases, including interstate and also individual claims. It's obvious that the court agrees with this approach in Georgia versus Russian Federation, second interstate claim, when it uses the same terminology from Cyprus versus Turkey, as well as Ilashku versus Moldova, where the effective control of the territory, whether it's lawful or not lawful, as well as the authority exercised over the local administration, that means by a state over de facto agents, is actually present within the decision of the court. I think this is the very first issue. The challenge which the court would be facing in relation to the jurisdiction, where it might have somehow an influence on interpretation of IHL, I think it's not the question of the control itself, but the moment of the control, from which moment it will consider actually that there is effective control of the territory or authority over the local administration, because somehow it can always be interpreted by the applicant state or actually by other states who are benefiting from this interpretation that this amounts to, for example, occupation. This might amount to annexation. And on one side, I think it's inevitable because both human rights law as well as law of occupation, particularly under Geneva Convention 4, gives no gray area and allows no gap on protection. And in this way, both fields of area have the same approach. So let's see how the court will tackle this issue, because as you know, in case of Georgia with Russian Federation, the jurisdictional aspect of the control has been would be decided with the merits. So this is one issue. I think that I'm overarching over the time, right? And perhaps another issue would be interesting. Well, it will come actually in Armenia, Azerbaijan, and Ukraine versus Russia as well. Another issue, which also Michael mentioned, is the stand taken by Georgia, is that it has not derogated from the European Court of Human Rights. We have seen a different approach by Ukraine, but again, the Russia's position, the respondent state's position will be interesting in the second pleiad of interstate cases. I think it's a very policy-wise decision of the state in every individual case whether to derogate or not. I think it's a policy decision from the perspective how you feel to be perceived by international community, and whether you think that you have an obligation you can protect, as well as whether you feel that you have an opportunity to protect these rights. And I think the position of state, at least the position of the Georgian state, has been very clear. If you are in a situation of armed conflict, it's inevitable, and it's also present with the practice of the court. You have to take into consideration the realities on the ground. Therefore, you're going to be interpreting human rights rules in line with IHL, and you have mentioned Hassan case, which is exactly very good example on arbitrary deprivation of liberty. But before that, the same has been done in pleiad of Chechnyan cases when we talk about Isaeva versus Russian Federation, when we're talking about targeting, right to life, targeting of the villages, when we're talking about the application of conduct of hostilities issues. And the same happened, but not so widely with respect to property rights, as well as the rights of POWs in Cyprus versus Turkey. Therefore, it was obvious of Georgia that the court has a well-established practice of using actually IHL to interpret rules of human rights law. I will stop here, and perhaps then we will have also opportunity to talk about the third issue, which is very interesting. That's the evidentiary standard within interstate cases. I stop.
Thank you so much, Tamar, for your remarks. I find it very important to explain, and you've done it well, that the court is a resource for states and not only for individuals, and that states can also want to protect individuals through such mechanisms, and also that the court has to be aware that it is sending also judicial but also policy messages to states when adjudicating on those issues. Last but not least, I'm looking forward to hear from you, Andrew.
Thank you very much, and I've very much enjoyed the panelists' interventions so far. I've actually learned a lot, and I'm going to try and react to some of it as we go. So I was invited to speak on this topic as a practitioner and not as an academic or professor. So I'm not going to get into the whole lex specialis debate and the doctrine and the different schools of thought. I'm going to maybe just reflect some very practical points. So I have argued international humanitarian law before national courts and before the European Court of Human Rights. And I do get the question, why are lawyers taking IHL cases before a human rights court? And the answer is quite simple. There is no court to take an IHL case. If there was something called the Geneva Court of International Humanitarian Law, the cases would go there. But because it's the European Court of Human Rights is really the only place to litigate your complaints about whether it's mistreatment in detention or loss of life in an armed conflict, that is where the cases are going to go. And the same applies at the national level. It's very difficult to bring an IHL case before a national judge, and it's relatively easy to bring a human rights case. The United Kingdom, which obviously I know better, it has something, as many of you know, called the Human Rights Act, which means that you can bring a complaint before the UK courts. And it could be about something that happened in armed conflict, but it's going to be framed as human rights because that's the jurisdiction. There isn't something called the International Humanitarian Law Act. There is something called the Geneva Conventions Act, and you would think that maybe because that is supposed to incorporate the Geneva Conventions, that you could then bring a complaint under the Geneva Conventions Act. But you can't, because the Geneva Conventions Act is about prosecuting people for grave breaches of the Geneva Conventions. It sets up a criminal jurisdiction. It's not a civil jurisdiction. So all of this explains why human rights lawyers are bringing claims which other people would say are essentially IHL claims. If you add to the mix that not only is there very little chance of getting a jurisdiction for an IHL case at the national level, but even if you did, national judges, when they see a complaint about armed conflict and armed conflict law, are very reluctant to adjudicate. And there is a book by a former student and assistant at the Geneva Academy, her doctorate, Dr. Sharon Weil's book. And she gives multiple examples of where people have tried to bring an IHL claim in a national court. And she has some very good theses where she explains that the judges will avoid dealing with these armed conflict issues. They will refer it to other branches of government. Or they will use the law of armed conflict to bolster the legitimacy of what the government is already doing, to explain why it's legitimate and acceptable. So it is not a place where a victim's lawyer is going to go. They are not going to go to national court and complain about IHL because of all of these reasons. On the other hand, there will be constitutional rights claims that you can make or human rights claims that you can make. And so instead of talking about a grave breach of the Geneva Convention, one talks about a violation of the right to life. Instead of talking about a violation of Common Article 3 to the Geneva Conventions through mistreatment of the detainee, one talks about torture. And that is why, basically, you get these IHL complaints dressed up, if you like, as human rights complaints in order to get jurisdiction. Now, I mentioned that because it explains, I think, why, when the case gets to Strasbourg, there hasn't been an argumentation about all the international humanitarian law points, because it will have only been argued as a human rights case. And as Michael O'Boyle has explained very well, when it gets to Strasbourg, the Strasbourg judges might want to take into account other branches of international law, which were not necessarily available to the national judge who is fixed in human rights law, constitutional law, or the European Convention on Human Rights, with no possibility of looking to these other branches. So I was involved in a case which has already been mentioned in Strasbourg in 2008. In full transparency, it's the case brought by Georgia against Russia, and I was on the Georgian side. And we argued that the court should hear these complaints, in particular about loss of life under Article 2. And as Michael O'Boyle explained very well, the respondent government, my notes call it the respondent government here, but I think now it's clear that it's Russia from everything that's been said. So I can say that the Russian government basically argued, as Michael O'Boyle said, that the court should have no jurisdiction as the case should be dealt with exclusively as a matter of IHL and therefore not at the European Court of Human Rights. And the court's response in its admissibility decision was to say the following: Article 2, which is the right to life, must be interpreted insofar as possible in the light of the general principles of international law, including the rules of international humanitarian law, which play an indispensable and universally accepted role in mitigating the savagery and inhumanity of armed conflict. And my point there is that they are applying the European Convention on Human Rights, but interpreting it in the light of other international obligations which are binding on the same states that have ratified the European Convention. So it's an interpretative renvoi, if you like, to IHL. But we have not gotten to the point where IHL displaces the human rights completely and therefore leaves the European Court of Human Rights without jurisdiction. Nevertheless, the European Court of Human Rights did not decide the matter and said that they would come back to this point when it comes to the merits. So we are waiting to see, in a way, what will happen when we come to battlefield killings, if I can put it like that. And we can talk in a moment about the Hassan case and the detention cases. But I think this is really the big challenge ahead for the Strasbourg court. How will they deal with issues which have in the past been seen as questions of the laws of armed conflict, but which of course can also be expressed as human rights questions? Now, let me mention Hassan because it's been mentioned so many times, and I'll give you my own thoughts on it. In that case, the Strasbourg court developed this interpretation idea so that the protection already found in the European Convention on Human Rights is read and interpreted in a way so as to accommodate the protection regime in the Geneva Conventions. So in this case, they held by a majority that internment by the British in Iraq in time of occupation was not listed as a permissible grounds for the deprivation of liberty in the European Convention, but they read in the authorization which you can find in the Geneva Convention 4, so that the detention was not in itself inherently unlawful. And then, as Michael O'Boyle explained, they checked that there were procedural protections with Geneva Convention 4 in place. And I think it's very important, that last part, because what this was a case about international armed conflict. And the judgment states at one point, and I'll quote, "It can only be in cases of international armed conflict, where the taking of prisoners of war and the detention of civilians who pose a threat to security are accepted features of IHL, that Article 5 could be interpreted as permitting the exercise of such broad powers." And I think what they were considering there was that Geneva Convention 4 and Geneva Convention 3 create a coexisting protective regime. And where they saw there was equivalent protection to be offered by those regimes, they felt comfortable saying, okay, the IHL regime here can be read in to the human rights regime. When it comes to non-international armed conflict and the detention of people in a non-international armed conflict, the court would have to consider that that protective regime and the procedures that go along with it would not apply. And my prediction is that they will be quite hesitant to say there is an implied power to detain in a non-international armed conflict in the same way that they did when they applied Geneva Convention 4 and Geneva Convention 3. Because if you are in those international armed conflict regimes, a whole set of separate protections will apply. For example, you can demand that you have the right to a visit from the International Committee of the Red Cross. The grave breaches regime will apply. You have the right to have your detention reviewed periodically, at least every 6 months, and so on. All of these things I think the court was taking into account. So it's not IHL in the abstract which is being incorporated or accommodated, but it's a particular protection regime. And there's a paragraph in Hassan which is not often quoted. And there's a part there where they reference the International Court of Justice, and then they go on to say, quote, "The protection offered by human rights conventions and that offered by international humanitarian law coexist." In other words, there are two protection regimes. But if one of the protection regimes is not adequate, in other words, IHL in non-international armed conflict, the court might have a pause for thought. And those are my thoughts, that I think it's very important the extent to which IHL is actually operating as an equivalent protection regime. And I think that's a part of the way in which the court will think about it. As many of you know, this has been litigated in the United Kingdom, and in the High Court, in the Court of Appeal, and the Supreme Court, the judges felt that Hassan should be limited to international armed conflict. And when the court says only in international armed conflict, that's really what they meant. And they declined to say that IHL provided a ground for detention. You have to have a human rights explanation. And if you haven't got that, it's going to be a violation of human rights. Now, just the last point on interstate cases. It's been covered, but I'll just add a couple of points. Why go to a human rights court in an interstate case? Why not go to the International Court of Justice or to arbitration? And Tamar has put it very well. You might not have jurisdiction at the International Court of Justice, and you might not be able to get the other state to agree to an international arbitration. But I've been thinking about this, and I think there might be another reason as well. And that is that it's quite difficult, even if you go to arbitration as Ethiopia and Eritrea did, and you get a result and you are owed money, or you go to the International Court of Justice, like the DRC and Uganda case, and you complain about IHL violations. How are you going to get your money? How are the reparations which are ordered, or the other measures which are ordered, going to be enforced? And sorry, I think I lost the sound for a second. The point about doing this within the European Convention on Human Rights is that, of course, you are at a court which is within a regional organization, within the Council of Europe, which is a political body. And that means that the Committee of Ministers and the Secretary General are going to weigh in and somehow put political pressure on the states to either pay up or abide by the judgment. And I think we sort of forget that the European Court of Human Rights is not just an abstract court sort of in isolation. It's within a political environment, and that is very important. And the last point, and it was stimulated by what Michael O'Boyle said about Azerbaijan and Armenia, and I have to say I had to go away and check the press releases after what he said. And one might be left with the impression that somehow the European Court of Human Rights is really only concerned with the human rights of civilians, and that somehow the human rights of prisoners of war are going to be taken care of by the Geneva Conventions regime and the ICRC. But they seem, and I checked it since Michael spoke, they seem, if I've understood correctly, in November to have issued a third press release which clarifies that it is not only the rights of civilians that they care about, but they care about the right to life and the right not to be tortured for everybody in captivity. And so even if the complaint at the interstate level was about mistreatment of prisoners of war, the court will still look at it because it's about the right to life or the right not to be tortured. And there's a sort of comma that they talk about the protection of civilians, and then they say, and all of those protections which apply to the right to life and torture. And therefore, the fact that your complaint is as a prisoner of war does not take you out of the human rights regime if it relates to one of your human rights. If it relates to an IHL right, the right to be visited by the ICRC, say, then the European Court of Human Rights might very well say, you're asking us to judge the Geneva Conventions, that's not our job. But if you are a prisoner of war and your complaint is that you are being tortured, or if you are a state and your complaint is that your soldiers are being tortured, then it falls smack within the jurisdiction of the European Court of Human Rights, and they're going to deal with it. And I'll stop there. Thank you.
Thank you so much, Andrew, for the clarification on on the press release and Armenia and Azerbaijan, but also on the other points with regards to how the court brings in not the legal framework of IHL as such, but mostly rules and protections that make sense. Now, if it's fine with everybody, I would like to open the floor for the Q&A session that will last about 40 minutes. I would also like to use this occasion to say how happy I am to see about 130 of you, and also many familiar names from friends, also colleagues, and from the academy. So hi to everybody that we know. The first question that has been asked, I'll go back to it. So we have a few questions already, and feel free to keep them coming. We'll stop it if we don't have time. But the first one is addressed to everybody, but perhaps mostly to Tamar, about your comments on the court's approach to evidentiary issues. Is there an identifiable standard of proof, especially with regards to effective control? Tamar? Oh, I think, yeah.
Yes. So I think there is two different issues. First one is about the evidentiary standard when it comes to effective control. I think the practice of the court is evident, starting with the Cyprus and Turkey interstate application when we are talking about the effective control test, when we're talking about the control of the territory, the presence of the troops there. Later, actually, it has been debated before the court within the admissibility level by respondent state arguing that the challenge is in relation to not that basically this is the second standard which has been developed by court in relation to Moldovan cases. It relates to the control exercised by respondent state over the administration or so-called de facto agents. And by that way, court having a jurisdiction, attributability of the action, and therefore jurisdiction over the violations. I believe the one of the issues has been raised by the respondent was to limit the jurisdiction of the court's jurisdiction with respect to the control of the territory, and arguing that if there is no effective control of the territory, you cannot talk about the authority exercised by the state with respect to local authorities. However, notably in its pronouncements, and I'm unfortunately not able to cite the paragraph in admissibility case, the court agreed with the applicant state, arguing that you can have actually exercise the authority over the local administration, which can be through support, which is given, overall support, which is given to the de facto authorities by the respondent state. This is the one aspect of the issue. Now, the second aspect, I think, which is the biggest challenge for interstate cases when I referred to the evidence, when we are talking about the situation of the armed conflict, is the access to the evidence and the standards. And here, I believe, at least in case of Georgia, and somehow I have a feeling that the same would happen if we have approval of admissibility in Ukraine versus Russia. With Armenia, Azerbaijan is yet had to be seen if the submissions will be filed either by Armenia or Azerbaijan after interim measures, is the question of the fact that somehow court becomes a fact-finding mechanism because it has to establish the facts, particularly when the time has evolved and when we are talking about the conduct of hostilities, which relates to targeting. And unless you have an access to the witnesses who have been the victims of the targeting, one of the biggest challenges is that you might not have an access to demolished buildings and civilian objects, or also not have an access to the territory to take the evidence. This is one issue. However, what I see also and observed is that through the practice of the court, it's obvious that the court is heavily, at least late in this interstate case, is starting to rely on the reports by the civil society and other international organizations, which is a very good sign, because it is using existing mechanisms and existing reports heavily to find an evidence which is sufficiently substantiated. So it's a standard also employed by the court. And what we see being done quite often by the respondent state, rather than rebutting this objective authoritative report used as an evidence, more criticizing it. So it would be interesting also, I think, in relation to the merits of the case, particularly in case of Georgia versus Russia, how far the court will rely also on the reports presented both by the applicant and respondent, although there has been also witness questioning sessions before the court in 2016.
Thanks, Tamar. We have received about like 9 or 10 questions, so I suggest that we stop there and then take more if we have the time. So the next question is to the 3 of you, and there are actually 2 of them, and they relate to the Benkovic case for the application of the convention in cases where countries have not accepted the jurisdiction of the court, or when there is grave breaches of IHL by European countries in territories outside of the European space, so extraterritorial armed conflicts. So the first question is asking for your views on what the applicants in the Benkovic case mentioned about the initiation of a crime in European territory but have effects in other countries. And the second question is regarding the use of airstrikes, like in the Benkovic case, and the use of drones are new technologies for targeting that can be used in territories outside of Europe, but by European members of party to the European Court. So I guess more general thoughts on those issues. Andrew, do you want to start? Or Michael or Thomas?
Okay, I'll go for that first. On Benkovic, I think with regards to action outside of the European space, as it was called at the time, the court actually took quite a big step in the Öcalan case, where things took place in Kenya, or albeit close to the Turkish aeroplane, but the point was it was well outside of Europe. And because they extended the idea of extraterritorial jurisdiction to control over people, as opposed to this idea of effective control, which was obviously relevant for Northern Cyprus, I think the court's attitude to actions abroad is much more flexible than if you just read Benkovic, which is a sort of a decision of its time. It's not even a judgment, as you know, it's an admissibility decision. So if you take the Öcalan idea that a European state will be responsible for the acts of its agents when they have control over people, that allows for all sorts of complaints about IHL abroad. Now, of course, Benkovic was aerial bombardment, as you've said in the question. And the next step is to say, well, what then about a drone attack? And here obviously, you know, I don't know what the court would say, but I mean, there is quite a good argument to say that, well, when Öcalan was arrested by Turkish officers, you know, they put their hands on him and he was in their control. But that's not really so different than a drone hovering over you and about to kill you. I mean, the idea that one, because you're physically touching someone, and the other because you're a few hundred or 1,000 meters up in the air above the person, it's not so different than a sniper 100 yards down the street in occupied Iraq pointing a gun at you. So I think the drone example is going to force human rights courts, not just the European Court of Human Rights on its own, to reflect on what it really means to have control over someone. A sort of old-fashioned idea of a policeman putting his hands on you and putting you in handcuffs is obviously the paradigmatic example. But if you have a drone hovering over you that can take away your life, here's a very good argument from a human rights perspective that the state has control over you at that point, and it should be responsible for the acts of its agents. Those are my thoughts.
Thanks, Andrew. Yeah, go ahead, Tamar, and then Michael.
No, go ahead, Michael, afterwards.
Yeah, I just wanted to say that, as Andrew has pointed out, Bankovic is very much it's not a judgment, it's a decision of admissibility that was decided quite some time ago. And for anyone looking to understand the law of jurisdiction today, there are quite a number of very important judgments that they would have to look at, which qualify quite considerably what was said in Bankovic about jurisdiction being essentially territorial. I think the starting point for the court's analysis in these cases is to ask whether it's confronted with a territorial act, and there's an assumption of jurisdiction where that's the case. For extraterritorial acts, if one looks at judgments like Jalud against the Netherlands or El Skaini against the United Kingdom, and the recent cases that you've mentioned involving Moldova and Russia, you'll see that the approach is considerably different. They're prepared to find that there was jurisdiction when people get killed in the course of some sort of a road check, as in Jalud. So all of that has got to be seen. These questions of jurisdiction are not easy to resolve. The court has been criticized to some extent for not giving a consistently clear account of what the parameters of its notion of jurisdiction are. And my response to that would be whether or not that's at all possible. On the drone question, there is no decided case that comes anywhere near that. So that would be a totally novel question, but undoubtedly one that may well be raised with the development of technology in the near future. And arguments will be made, as Andrew has made them cogently, that there isn't that much of a difference between the control over a person in a road check situation or in a public order situation, as in Al Skaini, and when a drone is flying overhead with the capacity of obliterating everything underneath it. But that's a case that has yet to be decided.
Thank you, Michael. Tamar?
I think just the way I read the Bankovic is that there is three elements that the court, just the third one it didn't discuss. Is first is European space. Second had been actually the challenge which retains is the that basically the control of the space doesn't amount to control of the land. And the third one, which it didn't have to go, but it then went in Behrami case, is that how you can actually discuss the responsibility of international organizations. And so just omitting, it was happy with the first two to strike, I with all my due respect, to deal with the issue and not go to the third aspect, which is attributability of the violations to the international organization, which then it's dealt in Behrami case. So I think if the new case comes up where you have only first two parts, either European space, which as noted also in extraterritorial applications by Turkey in Iraq already has been decided by the court, clearly saying that beyond European space we can go, the court might be more bold and let's say evolved to interpret broadly also jurisdiction, particularly because if I'm not wrong already, the Human Rights Committee has done this way lately in its general comments when it relates to the right to life. We also have a lot of group of experts within the United Nations as well as beyond United Nations looking at the issue of the jurisdictional aspects of the drone strikes. And also the court has been broadly interpreting also the jurisdictional aspects related to other rights, but which is also not related to the control of the territory, which is intelligence gathering by, if I'm not mistaken, the Five Eyes, which is a case brought also before European Court. So yes, the land control remains an aspect, but perhaps already the fruit is ripe to also overgo that step.
Thank you, Tamar. So our next question is to Professor Clapham from one of your students, saying that it seems that most of states are reluctant to accept the application of human rights obligations in situation of armed conflicts. But the fact that they don't adopt appropriate domestic legislation to allow adjudication of IHL rather than human rights seems to be contradictory. Don't you think?
I'm not sure it is contradictory. States don't like being held accountable, and so they make arguments as to why you shouldn't be able to accuse them of violating international law and claim your reparations. So they will say, this is an IHL case and it's not a human rights case. Human rights law don't apply in armed conflict, in order to avoid their responsibility. They are not saying, take us to IHL court because that's the appropriate place, because they know there is no IHL court. So I think the two arguments, in fact, lead to the same place. Don't hold us accountable. We want to call this an IHL violation, not a human rights violation. But that's not because we expect to be held accountable to IHL. We know we can't be. I mean, I'm sorry to put it so bluntly, but I've had some quite obscure and bizarre conversations with states explaining to me why this should be dealt with by IHL. And I say, okay, but where would we take the complaint? And they say, well, you take it to the ICRC. That's the people who deal with IHL. But from a victim's lawyer perspective, that's not useful to you for all the reasons we know. The IHL, the International Committee of the Red Cross, is doing a very good job visiting people, writing their reports, which are confidential to the government, but they are not in the business of adjudicating whether the law has been violated and enforcing reparations payment for your client. So I take your point. It does look contradictory, and states play with that sense of contradiction that no, this is IHL, we should deal with it in an IHL way, but they know that there's nowhere that they would be held accountable for that.
Thank you. Sometimes blunt is good and efficient. There's another question for the three of you on, hi Mona. So, sorry. The question is, on the long-term perspective, does keep litigating IHL under human rights fora doesn't risk making IHL increasingly irrelevant? Tamar, do you want to go first? I see you smile. No? Okay. Michael,
I saw the question, so I'm happy, and then I'll let Michael come in. I mean, I'm not sure it makes IHL irrelevant. I think it makes it more relevant, because in each of these human rights complaints that are brought, in order to interpret the human rights law that is in litigation, you have to reference the IHL because it will have more detail, more specificity, more history, more case law in the context of war crimes law. So in fact, it's precisely because of the human rights litigation that IHL is becoming more relevant, and judges are forced to read the Geneva Conventions. The human rights cases that I've been involved in court, which raise IHL, have forced all the lawyers concerned to learn a lot about IHL, to argue the case and decide the case. So I suppose, again, at the risk of sounding contradictory, I think the more one litigates human rights in armed conflict, the more relevant IHL becomes.
Thank you, Michael.
Yeah, I completely share that. I can't say that IHL is becoming less relevant. On the contrary, I think it's becoming more relevant the greater the number of cases concerning armed conflict, be it of a non-international character or of an international character. And as I mentioned in my presentation, it's a feature of the last 10 years that the number of cases that raise these issues has increased dramatically. And my fear is, of course, that that's a trend that will continue. So, of course, people don't like IHL. It comes back to Andrew's point about judges not feeling comfortable applying IHL because they're more used to applying norms of human rights, where there is a court that has given created a corpus of interpretation as to how those rights are to be interpreted, whereas that's not the case with principles of IHL. But I remember a stage when if a lawyer raised an issue of human rights law before a British court, on a regular basis, it would be rejected on the grounds that this is way before the Human Rights Act, that this was simply not a matter that the National Court was interested in. And part of that was that judges didn't feel comfortable with this newfangled system of law. I think we find the same phenomenon with IHL. But as Andrew has indicated, the more these issues of IHL are reflected in the cases that are brought to the court, the more people, the more lawyers and the actors in the system, the judges, the members of the legal secretariat, as well as the parties and the third party interveners are required to do their homework and to discover what exactly is involved in IHL. And there they will discover a cornucopia of principles that are of exceptional relevance to situations of armed conflicts. That's where the term lex specialis comes from. So my answer would be rather clear on that point.
Thank you, Michael. Tamar, do you want to comment or?
I fully agree about the European Court of Human Rights with both of the speakers. I think is my voice heard? Yes. So yeah. I think one aspect which has also developed for last, if I'm not mistaken, 14 years, which I'm glad to see about the application of IHL, is within the Human Rights Council, where we see increased use of fact findings during the situations of armed conflict, and because of the broad mandate of the Human Rights Council, where it can look both at the human rights law and humanitarian law, we do not necessarily only see IHL used for the interpretation of the human rights law, but there is also a broad discussion of the violations of IHL. Therefore, it brings, somehow I see it also as an opportunity of creating a forum where we can talk about IHL per se and not discuss it within the basket of the human rights law. And observation, it's obvious that the judges are also learning. I fully agree with Andrew and Michael. The courts are learning IHL, and it's also good for the development of humanitarian law, because you didn't see a lot of discussion about the rules applicable in the occupation. What are the standards and how you have to comply with the human rights obligations in occupied territories, and it's increasing within the court as well, which somehow will make also states think about their own obligations under the law on occupation.
Thanks. Thanks. And I guess the multiplication of cases and places where IHL is being brought up really testifies to the appetite there is for it. The next question is again to the three of you. And it says, the panelists mentioned quite a few interstate cases. In the context of international armed conflict, some of the main questions presented to the court will be stemming from military activities of all sides, by individual complaints against the applicant state. In your experience, how does this influence, from both a legal and policy standpoint, state parties' positioning with respect to the importance of IHL and its interplay with the convention? Tamar, do you want to go first?
Okay, so from the state's perspective, I I think it's a good sign when you have individual complaints against the state, whether it's for negative, positive, or obligation, whether we are talking about the occupying power or occupied territory, doesn't matter, because it somehow stimulates the state to be mindful of its obligations under IHL. And under the human rights law, when we talk about the violations which happened during the armed conflict after the ceasing of active hostilities. And also, I think it shows the capacity of the state being open, frankly, because what I often hear about the interstate cases is that if there is a lot of applications, it is perceived only as the fact that there is a massive number of violations, but also it gives us opportunity to view that there is capacity for these applications to be submitted before the court. So somebody is working on that, has an understanding that there is violations, has the opportunity to voice the concerns of the victim. So it's a plus. And it also gives an opportunity for the state to view in advance, to do the prevention, what we quite often see as an obligations under IHL, to do an education so that you prevent the violations. And I see as the individual applications as an opportunity for the state to understand that it has to improve. And I think we have seen that approach taken by the Turkey with respect to the Northern Cyprus. Particularly, there had been a massive individual applications with respect to the property rights violations. And Turkey had been using different remedies actually to improve existing mechanisms, although not directly arguing that it's the de facto authorities of the Northern Cyprus, TRNC, who has to comply with these obligations, not Turkey. But it's obvious that they have been creating special property claim commissions to actually respect the property rights of the Cypriots who have been actually taking cases before the European Court of Human Rights. So for me, it's also a learning opportunity for the state.
Thank you. Either Andrew or Michael?
It's quite a technical point, but I remembered it, that in the interstate cases, there's a problem sometimes with exhaustion of domestic remedies. Mm-hmm. So that I think the question that's being put to us relates to the idea that the violations themselves will be violations of individuals' rights, and those individuals may have to exhaust domestic remedies. But then the case is being brought by the state, another state, in an interstate case. And in the Georgia-Russia case that I referred to earlier, the court refers to its jurisprudence, which is that if the complaint is really about an administrative practice by the respondent state, then that's a question for the merits, and it might not be necessary for each individual to have exhausted all the possibilities within the other state. So it's an extremely complex area. I think that the sort of bigger point that I would make is, in an international armed conflict, the victims who will be probably of the other nationality than the state that they're complaining about will probably not have obvious access to the courts of that state. So, I mean, if we took any big international armed conflict, so as not to avoid the ones which are currently, so as not to sort of prejudice all the discussion about the ones that are ongoing. But I mean, if you just had, just for argument's sake, state A and state B, and state A invades state B, the nationals of state B who are interned are going to find it difficult to bring their complaint at the national level in state A for fairly obvious reasons. And so the exhaustion of domestic remedies idea built into the convention comes under strain. Now, in an interstate case, you can see how one state can represent its nationals without those nationals having to exhaust all the possibilities in the other state. It's a bit of a complicated answer to what was quite a good and simple question, but these things crop up in an international armed conflict in an interstate case, and that's what actually a lot of the practical lawyering is about, is resolving some of those conundrums.
Thank you. Michael?
I'll just add to what Andrew has been saying, some very quick remarks. If you look at the old case of the old interstate case of Ireland against the United Kingdom, part of that case was rejected for non-exhaustion of domestic remedies. So there are precedents for that. But equally, what you're saying about armed conflict and administrative practice is valid. The court is aware that in a situation where there's a clash of arms, that recourse to courts may be completely illusory. And if you look at the admissibility decision, for example, in Cyprus against Turkey before the Commission, in the first Cyprus against Turkey case, but also I think the second Cyprus against Turkey case, Turkey was arguing that the Cypriots who were complaining ought to have brought their cases before the Turkish courts. And the Commission rejected this claim by pointing out that this was simply not a functioning remedy for Cypriot applicants to go before Turkish courts and plead their case. As for an administrative practice, in a war situation, I think you would find that there wouldn't be that much concern on behalf of the court with the question of remedies, because there would be a working assumption that the legal system had broken down. No, I can't hear you.
Thank you, Michael. Just as a small caveat, I don't think we'll have time to take all the questions remaining in the chat, so my apologies to people who have asked them, but also my gratefulness for everybody for being so engaged with our panelists today. So the next question is about states' responsibility, causation, and arms transfer. It's a bit long. So I'll read it. In the 1995 application of Tuga versus Italy before the court, the complainant, who was an Iraqi mine clearer, had stepped on a mine which was allegedly unlawfully sold to Iraq by an Italian company, failing to properly regulating arm transfer, and it was framed as a violation of the positive obligation under Article 2. The Commission, because it was an application for the Commission, concluded that the applicant's injury did not engage Italy's responsibility because there was no immediate relationship between the supplying of mines and the harm. This was framed as a problem of causation. In the hypothetical, and this is the question, if we imagine that the causal link would be more immediate, for instance, the use of UK-made arms by the Saudi coalition in the war in Yemen, do you think that this could enable the European court to find the conduct, for instance, UK arms licensing, as triggering the jurisdiction as means in Article 1 of the Convention?
Wow.
It's a good question, but does anybody want to take a go at answering it?
Well, I'll have a go. But of course, I won't answer it. But there are some elements to be thrown out there. If one looks at the judgment of the court in Barami, you'll see that there were issues about the laying of mines by KFOR. This was a case which resulted in children being killed because mine cleaning operations allegedly were not carried out effectively. So although that case was ultimately decided on the basis of attributability, that it was the United Nations UNMIC that was responsible for that peacekeeping operation. And that couldn't be attributed to any of the respondent states. There was no state responsibility, but it gives an indication that one could conceivably attack a state if you could demonstrate that it was not properly supervising its licensing system, or if there was negligence in the way in which that system was being supervised, or indeed corruption in the way in which that system was being supervised. And as a result of that, there were casualties that occurred in a theater of war. That's not that far-fetched, but you have a serious burden of proof. And of course, there, you're going to have to convince a national court to look at the issue. There you would have a domestic remedies problem. You'd have to put before the national court that there was evidence that the state wasn't doing its job, or the state authorities were not doing its job, or if it was a company, that the state authorities were not supervising the activities of that company in a sufficiently proper manner before you could get anywhere near establishing a case before the Strasbourg Court.
Thank you, Michael. It's Andrew or Tamar?
Well, maybe inspired by Michael's creative way into this. I mean, I think when you're before the national judge in that situation, one of the things that you would be arguing is that not so much the arms manufacturer had done something wrong, but the minister who authorized the export of the arms would have to take into account human rights obligations in their decision. So there would, of course, be an obligation on the company that was creating the arms, but the way in which it might pan out is that you would be seeking a review of the minister's decision, because arms exports, if they're done legally, will have to get an arms export license, and that will have to be granted by the government or by the minister. So your argument would be that the minister did not take into account human rights in the decision-making process, and that is an obligation of every minister. And some of you who have maybe followed this, you know, these arms exports to Saudi Arabia for the purposes of the Yemen conflict have been challenged in the UK courts. And that is sort of part of the argumentation, that the minister has to do everything to ensure that the arms are not going to be used in a way which could violate human rights or IHL in the future in the way that they're being used. And the Court of Appeal held that the minister didn't actually have a proper system in place. So it's going to be a complex argumentation, a bit along the lines of what Michael suggested, but the government is going to be in the middle of this because an export of arms requires a government export license.
Thank you. Tamar?
So I think I would differentiate due diligence obligation under human rights specific treaty and a customary law. I see it as a if we had a treaty, we have to look at the treaty's jurisdictional clause, which will include the due diligence obligation, what we call positive obligation under human rights law, because we have this specific type of obligation in the treaties related to arms control, transfer, etc. In my humble understanding, and I am not a person who specializes in human rights law, my understanding is that we cannot so broadly interpret the jurisdictional clause of the European Court of Human Rights to include such a due diligence obligation. Therefore, the court will not have a jurisdiction to do that. However, it doesn't mean that such a treaty cannot exist. It will be, in that case, to look if the treaty provides such a jurisdiction, for example, a very specific treaty. The other aspect, the third aspect, is if there is such an obligation under customary law. And with my understanding under due diligence obligation under public international law so far, what is established is that in environmental law issues, we can go so far, yes. On the protection of nationals, we can go so far, yes. And there is also in relation to human rights obligations. But with respect to human rights obligations, it's often limited to the treaties and the treaty scope. That's why I believe it would be difficult to actually bring such a case before the European Court of Human Rights.
Thank you, Tamar. On that note, I suggest we conclude. Thank you to the three of you for your presentation and for your detailed and creative answers sometimes. Thank you to all our participants for sticking with us this afternoon. Apologies to those who have asked questions that remain unanswered. But I hope that you've learned as much from our panelists as I have and enjoyed the conversation as much as I did. I wish you all a good morning, day, or afternoon, and look forward to next events. Stay tuned. Goodbye.
Bye.